This is a continuation of the letter that I believe my grandmother wrote concerning Bill and his behavior and how disconcerting it was. Number 5. On July 5th, 1988, Bill went to the parking lot at Children's Hospital while Peg was working and took the vehicle, truck, which she had always taken care of during their marriage. She used it while in Columbus. He called and told her he had left the other car on the street in the area. She couldn't find the car and had to have her mother come and get them and bring them home. It might have been from my grandfather's letter, I'm not sure. The next day, she found the car, but the front seat was permanently fixed so she couldn't reach the pedals. Bill is 6'3" and Peg is 5'2". Okay. In court, the referee, of course, let him keep the truck, but he was ordered to fix the seat and make the car safe and roadworthy. He brought an invoice with no details. Peg had our mechanic check it out, and he said it was unsafe. Exhaust fumes leaked into the back seat, and steering unstable. This car was the one he chose for his daughter to be transported in. See documents. He said he got new tires and gave Peg an invoice from Tire America. She got the original invoice, and discrepancies are obvious. See documents. In fact, he used his visitations to take the truck and gave up visitation with Bethany to do so. He had also called the insurance company the day before to make sure Peg had paid it. 6. Bill had lost and changed many jobs after Peg filed for divorce. He never told the court when he got a job, but always immediately filed for relief when he lost a job. 7. Bill called Children's Hospital orthopedic section and made an appointment supposedly for Bethany. He went there to talk to Dr. Roy, Bethany's doctor, and charged the visit to Peg's insurance. Since Peg's insurance only covered a fixed number of visits to Dr. Roy, Bill had thus taken one of Bethany's visits. See document. 8. When his truck was in the garage for repairs, he came for a visit in a nice, late model Honda. He told Peg it was a loaner. Later he came in the same car with Lynn, and Peg remarked that he sure had a nice mechanic to let him borrow such a nice car as a loaner. Lynn said, "It's not a loaner, it's my car." When he claims that Bethany jumped in his arms and his hand went near her groin, he said he went across 2 rooms to tell Peg. In fact, he only went about 10 feet to the door where Peg met him. I was at the window in the kitchen, and the couch was along the wall under the window, so I was right there. 10. Bill sold off almost everything of value and eventually put the rest in storage. He asked the referee to have Peg pay for half the storage fees, and she agreed, although she had no access to it. The referee, in an order, decided that neither could get the property without the other, and a day was chosen when they would divide it. We took the court order to Stronghold's storage, and he cut off Bill's lock and put on his own. Bill came to get property, and the manager would not allow him to take anything unless Peg was there. Peg finally agreed to take just a few things, nowhere near the amount coming to her. But there was money due on storage because of Bill's actions. He refused to pay and took both Stronghold and Peg's mother to court. All he got was the cost of his lock, and I was dismissed, yet he claimed in court that he won, and I was angry because he won. See document. So that's some more of Bill's absurd behaviors. Court appearances and what they were for. I have something here. Basically, none of these court filings or court claims had anything to do with sexual abuse whatsoever. And it was all based on custody and visitation and problems like that. 040588, bill, court, visitation arrangements, child support. 2. 051088, bill, court, visitation arrangement, child support. 051688, order, courthouse, custody, investigation together. 0606, order, 88, order, courthouse, custody, investigation alone. 072988, order, courthouse, custody, investigation with Bethany. 080288, bill, court, custody, pretrial. 081288, bill, court, visitation arrangements, property, childs. 091688, bill, court, custody hearing. 112188, order, courthouse, visitation, counseling. 122188, order, courthouse, visitation, counseling. 020289, bill, court, child support. 031789, order, court, property pretrial. 051089, Peggy, court, property division. 062189, Peggy, court, final decree. 062989, bill, court, final decree. 110189, bill, court, visitation arrangement and storage costs. 12 $89, order, courthouse, psychologicals. 01 $90, bill, court, stronghold securities and mom. This was written by my mom, I guess. Or her lawyer, I'm not sure. 082290, bill, court, visitation arrangements. 082990, bill, court, visitation arrangements. 090490, bill, court, visitation arrangements. 101090, bill, court, visitation arrangements. 012891, bill, court, objection to report of referee. 050692, bill, court, visitation arrangements. 082692, bill, court, objection to me supervising. 093092, bill, court, contempt. 101492, bill, court, visitation arrangements. 121192, bill, court, contempt. 010793, both, court, objections. 012793, bill, court, visitation arrangements. 020793, bill, court, visitation arrangements. 020993, Bethany, court, interview. 032793, bill, court, visitation arrangements. 051193, bill, court, contempt. 061093, bill, court, contempt. 071093, Peggy, court, child support. 091493, bill, court, contempt. 011194, bill, court, contempt. 020494, bill, court, contempt. 031694 and a question mark after it, bill, conference, contempt. 050394, bill, court, contempt. 051194 with a question mark after it, bill, conference, contempt. 071994, bill, court, contempt. 072994, bill, court, contempt. 080994, bill, court, contempt. There were many more hearings that came later in juvenile court and such, but my point is, there's nothing in there regarding sexual abuse or any false sex abuse claims by my mom or anything of that sort. These filings had nothing to do whatsoever with sexual abuse or abuse of any kind. Purely a matter of did my mom refuse visitation or not. Silly things like that. My mom proved 100% that she did not refuse visitation ever. So, what's the problem against her? Good question. Total court chaos. My mom made some stuff. The kinds of stuff the referee did. 31588 has changed employment. Was fired, decided to become self-employed. Evidence behind this, I'm not going to go into all the people who can witness for this. 4/21/88. For a substantial period of time, the defendant has involved himself in living and growing up arrangements of the parties of a minor child. Didn't help financially, didn't come to see her after the time she cried with colic, wanted me to come to Cincinnati to take a pay cut, demotion, loss of benefits, etc. 4/26/88-1. Wrongfully denied him visitation and has refused overnight visitation. Visitation was never denied. We started a schedule towards standard visitation and denied ad lib access after bedtime, etc. No overnight visitation was enforced at the time, excuse me, since she had been primarily in my care. What's written in the court document of 5/10/88, a quick business trip to Kentucky. Care had apparently been prearranged with my mother before I had even left town, unbeknownst to me. 2. She came in and noticed that Bethany Ann had picked up some nails that Father accidentally left laying around the bedroom. And 3. He notes that he went to Lamaze classes with wife. In response to this, Mother came into room that Father was in and found Bethany Ann in a different room picking up nails and putting them in her mouth. Only came to 2 classes out of 10 total. The court claims husband saw parties, child 7 times. Husband saw wife that many times, came after Bethany was asleep many times. 5. I'm court claiming Mother is proposing visitation of 6 hours of supervised and 4 hours of unsupervised visitation per week. Only for the first month. It was originally to extend the standard visitation. Motion 7/21/88. The claim of the court. The parties have tried to work this out directly, but the plaintiff has willfully refused to provide defendant with adequate visitation. I was never informed that Bill had a job until I got the motion in the mail. He was provided with extra visitation for 3 weeks and to let me know when he found a job to work things out. He said he was unable to visit during the day while he was looking for a job, yet he used both the daytime and nighttime hours at this time. Court document 8/17/88. The parties had made up a voluntary visitation schedule, reduced visitation significantly after husband removed marital truck from her. 3-week schedule whereby Bill could look for a job, said he couldn't visit during the day, visited 2 times during day, and removed truck during day. Husband states that he was given a wife, a Granada to drive. Response to that is, I had no idea where car was, I was unable to drive car, and he had the car in his possession. The court states, objects because she does not think it is roadworthy. I did not know if it was roadworthy. Bill indicated to me that it was not, and I should switch cars with him since it was unsafe to drive. Court says, husband began working at Architects Plus on July 1st, 1988. Response to this, husband began working at Architects Plus on June 6th, 1988. Court says, the agreement that the parties had previously worked out Tuesdays and Thursday evenings along with Saturday mornings. There was no previous agreement since I didn't know he was working. What I suggested was Monday, Wednesday, Friday evenings, and Saturday mornings for 3 weeks trial period if he could not visit during the day. For those 3 weeks, he had all day, Monday, Wednesday, and Friday, and Saturday mornings. Court says, she asked that Father notify each time he expects to exercise visitation. I asked that he let me know if he wasn't coming. Bill was asked that it be when he was going to visit. Court says, Father shall have visitation on Saturdays beginning at 9 a.m. and ending at 1 p.m. If Father, ... he may pick up child at 1 p.m. on Saturdays and return her at 5 p.m. in addition to the morning visitation. Response is, I was the one who suggested that if he wanted to go to some afternoon activities, may want some afternoon time. As was stated in court, it was either morning or afternoon on Saturdays, not all day. No proof of repair was delivered for what the court said on 9/16/88, defendant shall supply directly to plaintiff within 30 hours proof of repair to Ford Granada. Court says on 6/29/89, the marital property of the parties has been divided between the parties as specified in an agreed entry. There was no division of property to this point since Bill refused to pay storage costs. Court claims, with the exception of the property specified in Exhibit B, which property the ... within 10 days. Response, there was no division of property in 10 days. The court says 8/21/89, plaintiff William Bailey, Bennett Bailey. Plaintiff is Peggy Farmer, so they couldn't even get that right. That's pretty severe. The court also says, asks that he be granted the sum of $288 for ... from actions taken by defendant and her mother barring. I had no contact with them. We could not bar him from anything. I asked my parents to take down the court order and let them decide if they were to do anything. Bill came that night to retrieve items without me present. So we're talking about Stronghold Securities again. Court says 11/06/89, payment of storage costs. Father felt he was forced to continue paying on storage. This is so despite the fact that he had given Mother all items he was supposed to give her. There was no testimony as to why Father's locks were cut or replaced. There was no testimony as to ... Father was not forced to pay if he divided property as per the court order. He did not. Father had not given Mother all items. He gave her no items. There was no testimony because it was indicated it was in the wrong court. Court, 10/19/90. Parties had a commuter marriage until September of 1987. It was until October of 1987. They lived together for 1.5 months before wife left. Response to that, 3 weeks. Husband attended Lamaze classes, attended 2 of 10, was late for 1. Husband was a loving and active father. Rarely saw him unless I did the traveling. Likewise, during the marriage, it was strongly indicated by my mother's testimony and what she said that she barely saw him at all, that most of the time they had together was when she traveled to see him, and basically she didn't live with him except for 25 days. So, not very long. The court says Miss Carol Grant, when actually the name was Miss Carol Brandt. He met Mother at same time to assist her regarding concentration problems for studies at Ohio State. That's what the court claims. The response is, he met me once for 20 minutes. 7 for court, and what they claimed, forgot to take the Christmas present home with him. Response, intentionally left Christmas present on the chair. Court claims, according to wife, Amy. Bill said Amy, I said Bethany. He has clearly been helpful to wife when wife has been pregnant and or ill, according to the court. Response is inattentive, left me to care for Bethany after surgery, canceled all babysitters, didn't attend Lamaze classes, didn't help with move after orthodontic surgery. Sorry. Court says reading on separation anxieties. Response, what separation anxieties did she have when he didn't see her? Good point, since he never had a part in my life at the beginning because he refused to. It's hard to have separation anxieties. I agree with my mom there about that. Court says, Father points, ... visitation is actually sort of unsupervised. We all agree to that. Court says, is closer to Mother than she has been with Father. I never wined and dined her. She never called me. In response to that. That was for 10/19/90. Objection 205/91. As well as psychoanalysis for both the plaintiff and the defendant. I never knew of a recommendation for psychoanalysis of plaintiff. In the court record, it calls the person Norma Ginther when the name was Norma Ginzer. Defendant stated even before the divorce. Response to that is, this is true. Defendant did state. The desired results was what it was phrased as in the court record. And the response to that is, what are the desired results? So, basically there was a lot of court disorder. It goes much further than this, but these are just a few examples of silly nonsense that shows that the court didn't know what they were talking about. They can't get plaintiff or defendant right. They don't know names. They don't know times. They don't know why things are happening. Not the best kind of court order that you'd want. Okay, here's another letter. These are letters talking about how my mom did not refuse visits. I am writing this letter basically with my child's needs in mind. It is important to know that I have been gone for 10 years and have not been found. I have no reason to expose myself except in the interests of my child. I have nothing to come back to. Both of my parents have died since I have been gone, and their house and their farm have been sold. My biomedical engineering degree is useless in getting a job in my field after 10 years without further education or training. And my contacts with my family, friends, and former life have all been severed without catastrophic repercussions. Thus, the main reason I am writing is to ask for clemency is so that I can come and freely help my handicapped daughter adjust to her first year at a university in a different setting. To understand why I would ask for clemency, I will reiterate my history. I filed for divorce in December of 1987. The same year, my daughter Bethany was born. I gave my ex-husband, her father, Bill Bailey, liberal visitation. Just call before he came. Yet he would come after Bethany was asleep, 9, 10, 11 p.m., and not call before coming. Since I was living with my parents and visitation with me was infringing on my parents' hospitality and time, I asked him to call to let me know when he was coming, or if he couldn't come. His response was to take me to court. On 5/13/88, it was ruled that he could have visitation on Monday, Wednesday, and Friday from 9 to 5 p.m., and on Saturday from 9 to 12. Bill came to me saying he was looking for a job and needed more visitation. I gave him extra time in May and June and told him